Question is that the total sum to be allocated for head J of the estimates be reduced by $100. Minister Edwin Tong.
So we share Ms. Lim's concerns to the extent that we would, of course, want to support a litigant in person's access to our justice system. And I'm grateful to Ms. Lim for recognizing some of the efforts to handle litigants in persons in court. Both my ministry and the judiciary remain committed to ensuring access to justice for all. And indeed, one of the guiding principles of the Civil Justice Reform Committee, established by MinLaw, was to advance access to justice for all persons, including litigants in persons and SMEs. Let me highlight some of the other ongoing efforts. First, we are simplifying and streamlining legal processes and designing them with the ultimate end users in mind. The new rules of court, which is scheduled to come into operation later this year, will be written in modern, layman language, easy to understand and to apply. Forms and processes will also be simplified. Cases can take a judge-led approach where appropriate. Second, we are leveraging on technology to make legal processes more accessible and convenient, and to channel timely and useful information to those facing legal issues, especially litigants in person. For example, the Community Justice Centre, CJC's Automated Court Document Assembly System, or ACDA. This is a free online service that provides step-by-step guidance to generate and file certain court forms, such as applying for deputyship, which a layperson can do on his own. If necessary, court staff will also be available on hand to assist. Third, we have taken steps to enhance awareness and also support structures to help litigants in person. I spoke earlier about the improvements that we're making to legal aid for civil and criminal matters to support litigants of limited means who are unable to afford their own lawyers. The Community Justice Centre, CJC, also runs a one-stop help centre, HELP, helping to empower litigants in person. These provide support services such as free on-site legal advice and also emotional and psychological support through the Friends of Litigants in Person scheme. Elderly or less well-educated persons ought not feel intimidated or apprehensive in participating in legal proceedings. Ample support is available to help them navigate the court process. If the litigant struggles with English, the Community Justice Centre will endeavour to source for volunteers who are conversant in other languages. For litigants in person who require a court interpreter, they can make a written request, and the reason to have to make the written request in advance is obviously the number of interpreters might be limited. If all goes for Mandarin speaker or dialect speaker on the same day, there needs to be an allocation. So something in advance will be necessary. But to the extent possible, the courts will allocate the appropriate interpreter to ensure that the process can take place and that the individuals who do not understand English can still continue to take part in the proceedings. Certainly, the judge will not proceed with a hearing if one party is unable to follow the proceedings due to language difficulties. Ms. Lim asked about the translation of English court documents. For cases before the community courts and tribunals or cases involving simple court orders, litigants in person who need assistance understanding court correspondence may call the court's hotline. They will be assisted by staff who can explain the content of documents to them, either over the phone or on occasion in person when they meet. For other cases, if a translation is required, litigants can be referred to third parties who provide translation services. We are in the midst of exploring the CDCs and with LSPBS a range of options to assist litigants who need assistance with English court documents. And the avenues being considered are the platforms to explain the documents verbally in a language that the litigant is comfortable with, providing advice where needed, as you heard Ms. Heniso explain earlier, or in certain cases assisting with the cost of engaging translation services where needed. Ms. Lim raised some questions on the impact of COVID-19 on the courts and litigants in person. Some amount of disruption in the past year has been unavoidable due to the need to combat the spread of COVID-19, to save lives, and the pandemic has had an immense impact not only on court processes but really on all aspects of our daily life. There has been some backlog, and state courts has lost a number of hearing days due to vacation of hearings because of the circuit breaker period. Likewise, the family justice courts as well as the high courts. Nonetheless, as of present date, the vast majority of the cases which have been backlogged have been refixed for hearing, and many have already been disposed of. As far as remote hearings and more generally the increased usage of technology of courts are concerned, MinLaw and the courts are keenly sensitive to the needs of court users who are not represented and less technologically inclined. Ms. Lim asked whether litigants in person have the resources to use Zoom. They can do so on their own if necessary. Alternatively, those who require assistance can receive assistance through telephone or over the counter on online live chat or email communications. Remote hearings serve to make it more convenient for the user, ultimately. But those who are unable to do so can ask for their matters to be heard physically if they are unable to attend remotely. Alternatively, the courts have also set up dedicated video conferencing facilities in the courts to cater to litigants who themselves lack the means or knowledge to connect via video conferencing facilities. Ms. Lim raised the case of a resident who was looking at quantification of damages. This resident can avail himself of any of the above measures I've mentioned. In addition, the litigant can also write to the court registry to explain the situation, ask for an earlier hearing date, and they can do so through any of the various modes I've mentioned. I spoke earlier about how MinLaw is working with agencies to review the CDMF, the Dispute Management Framework. Let me address the specific concerns that Ms. Lim has raised in her speech here. Cases are heard by district judges who are designated as tribunal judges. They are empowered to handle cases in a less adversarial way and to ensure that proceedings are simple for litigants to navigate. The CDRT is not bound by the rules of evidence, and proceedings are designed to be judge-led. These judges are trained in mediation, and they continue to assist every case. They continue to assist in every case, assess each case, and assess the parties for suitability in mediation, even as the case proceeds on an adversarial basis. If, despite all these measures, after exhausting all attempts at an amicable solution, there is still a dispute, then the CDRT will have to make a decision and issue an order. These orders then have to be complied with. Ms. Lim spoke about the residents' concern that they can be ordered to stay out of their homes. Let me explain. What Ms. Lim refers to are exclusion orders, which require the respondent to temporarily move out from his place of residence. Such an order is intended to deal with the most egregious of cases. There have only been 2 exclusion orders since October 2015. The CDRT can only make an exclusion order if the respondent has failed to comply with the initial CDRT order, as well as the subsequent special direction, 2 times. The timeline in both cases for the EO roughly have been about 17 to 18 months between the initial CDRT order and the exclusion order. So for a period of more than 1 year, almost 1.5 years, this individual defendant has been disregarding the initial order, have been heard by the courts, and yet chose not to comply with the initial court order. Hence, where the court has shown evidence that the respondent is recalcitrant, continues to cause nuisance to his neighbour in contravention of the order, and remains in contumelious default, it is only right that firm measures be taken to stop the offending conduct and deter the continuation of the nuisance. And even then, there will be, and there are, statutory safeguards. For instance, the CDRT must consider the impact of the order on the contravening party and any other individual who may be reasonably affected by the order. Access to justice, sir, remains a key cornerstone of the ministry, and we will continue to advance our efforts in this regard. We thank Ms. Lim for her feedback and suggestions. Thank you, sir.
Ms. Lim.
Thank you, sir. One clarification for Minister concerning my suggestion on the translation of court orders into other languages. In his response, he mentioned that there were avenues available for staff or perhaps through the CDC network to explain verbally to the resident the contents of the orders. But I wonder if he will agree with me that having a written translation is certainly something that is a better and a stronger reference point for the resident, because sometimes when people talk to you, you can't retain the information or you remember inaccurately, whereas if you have a translated document, you can refer to it, and it is, in a sense, a more reliable source. So I'd like to ask again that the courts, through the CDC network or through themselves, do consider this avenue of providing a translation of court orders if such is sought by the resident and at a nominal fee, or if not free.
Outlined earlier, this is something that's being looked into by the CDCs working with the LSPBS. In the appropriate cases, we can consider full translation of the court document. But I think Ms. Lim would also appreciate that it is not in every case that a full translation automatically means that the person who is receiving this document, even in its translated language, can readily understand it. And that's why the suggestion earlier that I made, which I think Ms. Heniso also weighed in on, is for pro bono lawyers to assist in this process, not just in the translation, but also in the elucidation and explanation of the impact of the document and what it means to the litigant in person. That said, I think we continue to ensure that through various means, we want to ensure that the litigant in person is able to understand the process, understand what the judge is saying, what the other party is seeking to achieve, and this, I think, upholds the integrity of the process. So we will take these necessary steps to ensure that litigants in person will be able to understand the process through a variety of means.
Ms. Lim, would you like to withdraw the amendment?
Chairman, it's good to hear the court's continuing commitment to justice for all, especially litigants in person. And I would highly urge that the courts continue in this direction to address any gaps. And with that, I beg leave to withdraw my amendment.
Is the honourable member given leave to withdraw the amendment? I think leave of the majority is given. The amendment is withdrawn. The question is that the sum of $308,728,600 for head E stand part of the main estimates. As many as of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that the sum of $92,444,700 for head E stand part of the development estimates. As many as of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.